Welcome to the legal classes. So I am going to discuss about formation of company. So to form a company, as per section 3 of the Companies Act, minimum members are required. So minimum members for public company 7 members, in case of private company 2 members, in case of private one person company any person can form a company. Then the members must be file an application form before the registrar of company. It is, in short, it is called ROC. So along with application form, some minimum required documents need to be submitted. First document is memorandum of association. It is a important document for formation of company and running of the company business. So next important document, articles of association. It is called bylaws of the company or the procedure laid down under the articles of association to function of the company. Along with these two documents, if any agreement, it has to be submit along with application, and also the members must be submit their affidavit before the registrar of company along with application. It must be consist name of the first directors, name of the persons, and their surname and family name, nationality, their residential address. All these minimum requirements must be submit before the registrar of company. So after submission of this application form, the registrar of company go through the documents. If it is correct, all the information is correct, they have to issue a registration certificate. So if it is not correct in the minds of registrar of company, if it is not correct, it may be rejected. The application may be rejected. So as per section 7 of the Companies Act 2013, companies can be registered before the registrar of company by filing memorandum of association, articles of association, if any agreement between the members, and affidavit by the members who conceived idea to formation of company. And along with that affidavit, they have to submit their full details, including declaration in case of any false information by the members or first directors. They have to liable to be punished as per the law. And also they have to disclose that they were not convicted any criminal offences for formation of company, management of the company, or in case of any fraud committed by during their formation of the company. So the offences relating to formation of company, management of the company, or functioning of the company. So by previous convictions must be disclosed before the ROC. For filing all these informations before the ROC, they can obtain certificate, that is incorporation certificate, issued by the registrar of company. Certificate of the company, so it is a conclusive proof that the company is formed by the members of the company. So in case of previous agreements, previous transactions, if any, in the name of company, all are void. So after formation of the company, the transactions are valid. So before formation of company, any transaction in the name of company is void, not enforceable by law. If any transaction after formation of company, it is a conclusive proof that previous transactions are not valid, they cannot be enforceable. After formation of the company, the company business will start. A company born with artificial person as a artificial person, so the life of company will start after formation of the company, after registration of company, before the register of companies. So in case of any false information, false affidavit filed by the members, they are liable under section 447 of Companies Act 2013. So along with other provisions of the law. So that means the directors or first promoters or first directors must be submit a valid information, a correct information which is true in the best of their knowledge. In case of any false affidavit, in case of any false information, they are liable to be punished as per law under section 447 of Companies Act 2013. Is the registration certificate the certificate of incorporation, so issued by the registrar of company. It is a conclusive proof. So conclusive proof means, as per Indian Evidence Act, the proof cannot be disproved by allowing witnesses. It cannot be challenged. Where a conclusive proof, there it cannot be challenged by allowing witnesses, by testing its validity. So that the certificate of incorporation having conclusive proof. So in Musa Ghulam Arif versus Ibrahim Ghulam Arif. In this case, the Privy Council held that once certificate of incorporation issued by the registrar of companies, it is a conclusive proof. It cannot be challenged. It cannot be questioned. So this is important case for formation, incorporation of company, certificate of incorporation. So this is the a way for formation of the company and registration of the company under the Companies Act 2013. So thank you friends, and please like and subscribe the channel. It will gives encouragement for making of future videos. Thank you for patiently listening. Thank you.